I don't know much for you all. I'm Landon Zinda. I worked on the Hill for the last 8 years. I work at Coin Center now. We're a nonprofit think tank in DC dedicated to issues related to cryptocurrency. Everyone there has been there so much longer than me. They've been there for 10 years. And speaking of Consensus, we just had our dinner there at Consensus. If you haven't been, you're invited. You should come. It's a great event. It's the best thing at Consensus. Well, with that, I don't have much else. I'm happy to chat about stuff, but I appreciate y'all being here and happy to chat afterwards as well.
Don't let him off the hook that easy. Okay, this guy's a wealth of knowledge, so we need to give him some questions. Who's going to come up with a good question for him? Oh, we got one. Hold on.
All right, I'm going to put your Senate knowledge to question here. So yeah, you're the Senate expert. What are your thoughts on the prospects of Stabenow getting something done by the end of the year? How are you thinking about that? What do you think in terms of likelihood? Seems tough.
It's a good question. It's good analysis as well. I'd want to start it by saying the people in the House did years of work to get to this point. I was a very small part of that. Allison and Paul did a tremendous amount of work to get Fit 21 across the finish line. That was at least a 6-year process just to get there. And there's a lot of criticism after the fact, which is totally apropos for our industry. But I think it's a major milestone and something worth thinking about, reflecting on, and appreciating. So with that, it does go over to the Senate. There are some also very smart and talented people working on it there. They've been working on it for years as well. And it's tough. It's coming up on the election. There is some momentum, as Ron mentioned, but it's going to be tough. But that I started in the House because it is this multi-year effort, and just because if nothing happens this year does not mean that momentum cannot continue. So there's a lot of people putting in a lot of work and effort into it and taking a lot of input from everyone. And if you haven't provided that input already, they're happy to talk to you and include your thoughts. And that's how legislating work is coming to a compromise and trying to move something forward with a coalition of people that can agree on it.
One more.
Yeah. Who are y'all going to sue next? No, really though. If you could just give us a brief update on what's going on with all of the myriad lawsuits and litigation and what's going on.
Yeah. There's so many options. I say that as a joke and then go back and consider who to sue. So as you might know, we're suing Treasury over Tornado Cash sanctions. They only have the authority to sanction people and property thereof, and Tornado Cash smart contracts are neither property nor people. And so we are questioning their authority. There's been some recent developments in that case, especially related to SDNY prosecutions of Samurai Wallet, and both DOJ and SDNY have argued that people that contributed to Tornado Cash have run an unlicensed money service business, that Samurai was an unlicensed money service business, despite there being guidance from the people who implement those laws that you would have to take custody of assets in order to be a money service business. And so the prosecutorial arms of the federal government and the states have gone past what Treasury itself says is required to be a money service business. So in those instances, we're seeing, rather than regulation by enforcement, we're seeing regulation by criminal prosecution. And to go back to Fit 21 and the question about the Senate, this is a multi-year effort. And to connect it with this, there's a great office, which I don't think Lizzie is here anymore, but Tom Emmer's office is great. He has introduced a bill called the Blockchain Regulatory Certainty Act. That bill has been in Congress for about 6 or 8 years. which basically says if you do not take control of customer assets, you do not have to register as a money service business. And that's a bill he introduced several years ago, and now it's more relevant than ever. All that bill does is cement into law what FinCEN's existing guidance is, which is that you have to actually control customer assets. And Tornado Cash, the smart contracts, never did. You always had control of your own assets. So that's the first lawsuit. I'm pretty optimistic about it. I was in the Senate at the time and joined Coin Center after the lawsuit, and I remember talking to OFAC about this and being highly suspect of their own logic about how they got to sanction smart contracts. So I'm pretty optimistic about that. The second one is we're also suing a different arm of Treasury, the IRS, for a provision that was in the infrastructure bill called 6050I, which would require any person in trade or business with making transactions of $10,000 or more in cryptocurrency to send information about themselves and who they're sending it to the IRS for tax purposes. The problem there is you're also sending wallet addresses, information about individuals that never wanted that information to go to the government. And when you send those addresses, that enables a huge amount of data to be collected if you're using one single wallet to make daily transactions, to do all sorts of things, to make politically unfavorable transactions, whatever those might be. That is allowing the federal government to amass a lot of information about that individual. And so we're suing them on that as well. Next, I don't know. I would double sue Treasury again, I guess. Just over this summarized stuff and the stuff I talked about before, that it's a tremendously irresponsible way to run government, to have a body implement a law, provide guidance, and then to sue the people who follow that guidance under some different rationale that was never explained to them. So that's I think a topic that Coin Center would like people to focus on.
One sec.
I don't want to take us into a deep legal discussion or put you on the spot to even have that, but I just am curious, and we can keep it at a very high level, is that there are actually 2 counts or more than 2 counts in the Samurai case. One of them is the money transmission issue, but the other is the 1956 the criminal statutes for money laundering, which don't turn on the fact that you're a money transmitter, that if you're aiding and abetting or being willfully blind to the activity. And it seems to me that's much more serious. And in the cases we've seen in the past, that's where ultimately, it's nice if they can get a 1960, the failure to be a money registered or licensed as a money transmitter, because it's a slam dunk. The proof level is a lot. It's non-existent. But on the 1956, that's really if you're aiding and abetting or being willfully blind to the money laundering going through the system, that seems like a more serious case. And have you talked about, how you would position arguments against that?
We definitely thought about it. I mean, you're right. Those are more serious charges, and we don't have all the facts we will let that play out in the court. You're right that that's more serious. What we've focused on is some of the charges related to being a money service business, and the law there is fairly clear, and anyone can read it and look at the facts of what was happening there and see that they weren't a money service business. But you're right, for the other criminal charges, that's something that's going to have to play out in court.
Okay. Thank you, Landon.